Professor Kress, thank you very much for joining us on this space in our YouTube channel. It is a real pleasure to welcome you. As Director of the Institute for International Peace and Security Law at the University of Colonia and Director of the Institute of Criminal Law and Criminal Procedure at the same university, your work has long stood at the intersection between international law, criminal law, and the legal regulation of war and peace. Your experience also gives you the distinctive perspective on these issues. You were a member of Germany's delegation to the Rome Diplomatic Conference that established the International Criminal Court. Later, you have served as head of the drafting board for the court's regulation. You worked as a war criminal crimes expert for the Prosecutor General for East Timor and have served on the advisory board on international humanitarian law to the German Red Cross. Since 2021, you also have served as special advisor to the prosecutor of the International Criminal Court on the crime of aggression. And besides that, now you're judge ad hoc at the International Court of Justice in the case of Gambia against Myanmar. Your academic contributions regarding the prohibition of the use of force and the right to self-defense in situations involving state participation in acts of force by private persons is especially relevant to the many questions that we're facing today. In your own account of your academic trajectory, you identified the questions of war and peace in its international legal dimensions as central and enduring concern of your work. With that context in mind, we would like to start by addressing a first opening questions about how would you describe the current state of the international legal order considering today's geopolitical tensions?
First of all, many thanks, Mr. Romero Morales, for having me. It's a great pleasure to return, albeit only digitally, to Universidad Externado, and for having me for this conversation. On your question, let me state the obvious right away. The international legal order is at a very difficult moment in time, at a moment of crisis, which is probably considerably more serious than the many crises international law has undergone since the entry into force of the United Nations Charter. Why is this so? The key reason, in my view, is that not only one, but two of the most important global powers have distanced themselves from the respect for the international legal order. First of all, the Russian Federation, of course, with a year-long aggression against another independent state in Europe, Ukraine, a year-long use of force, unlawful use of force that in 2022 escalated to an outright war of aggression, a violation of the prohibition of the use of force, which probably, because it entails the denial of the right of an entire state and population to independent existence and an outright claim to annexation and destruction of this state, is of an unprecedented gravity. But second, we have had to experience over the past years that also the United States, under the second administration of Donald Trump, has turned away from the international legal order. The president himself has declared that international law is not considered to be relevant by himself, and we have seen instances in most recent times of as well a blatant disregard of most important rules of the international legal order. And this, of course, two major powers turning away from a basic respect for the international legal architecture puts this legal order under serious pressure. Now, this is not the only factor that characterizes the present situation. We have, even before the most recent escalation of Russia's war of aggression against Ukraine, we have seen a declared intent by two major powers, this time Russia and China, not to turn away from international law completely, but to rework, to reform international law in a way that would undo certain important developments that the international legal order has seen over the past decades. And by this, I mean to return to an international legal order which is essentially of an interstate nature. So those two states, very openly in an important document in 2016, have made it clear that they are not in agreement with major developments like the enshrinement of a body of international human rights law in the international legal order, that they have doubts about important aspects of the development of international criminal justice and related developments in the field of traditional immunities and their, so to speak, step-by-step reduction where crimes under international law are committed. And so these states have made it clear that they are not content with a development of international law over the past decades that brings into play the idea of an international community which overarches sovereign states and their interrelation, and which brings international law into play even within the sovereign state of individual states, if those states vis-à-vis their own populations act in contradiction, in contravention of most basic rules. And in the most recent past, we have been able to observe that in the United States, under the Donald Trump presidency, there is also what I would call an authoritarian turn, which makes this threat to the idea of international community, overarching states, even more powerful. We have now an alliance of three states that very openly lean to an authoritarian model of government. And if this trend is to prolong, is to perpetuate itself, we are faced with the possibility of international law in general turning more in the direction of an authoritarian character. This is how a scholar like Tom Ginsbury has portrayed this possible development in an influential essay. So this would be an international legal order which would facilitate cooperation between states, but not with a goal to preserve fundamental human freedoms and liberties, but rather to limit them in an authoritarian spirit. So these are tendencies which belong or which form part of the current difficult situation of the international legal order. However, and this is important to state as well, this does not complete the picture. At the same time, we should be very cautious to declare hastily, prematurely, the end of the international law-based international order. We should be reluctant to declare the end of international law or major changes of international law to have already occurred just because there are these trends that I have mentioned. We should be aware that international law, as every category of law, has an inbuilt resilience against speedy change. By this, I mean that states like the United States may decide to depart from international treaties to the extent that treaties so allow. But the most fundamental rules of the international legal orders are non-written. They are customary in nature. And customary international law comes into existence usually over a longer period of time and cannot be changed overnight, even if the most powerful states so desire. So this is very important to avoid too hasty conclusions. And a second important element which a little bit speaks against this overarching sentiment of crisis, by and large, important international institutions continue working. And by those institutions, I mean, in particular, judicial institutions. Just think of the International Court of Justice, who is not only working in the same manner as it has been many years ago, but who is even in a situation that more states than ever have turned to this international jurisdiction, the main jurisdiction under the UN Charter system, in order to help this court to adjudicate conflicts or to give advisory opinions. And that shows that while certain states have distanced themselves from the international legal order, and very sadly so, there is an overwhelming majority of states who do not wish to depart from the international legal order, who wish to maintain this order and who have even got more active recently to avail themselves of the institutions that this international legal order presents. What follows from this analysis? That the future of the international legal order in this moment of crisis is an open one, that it ultimately will depend on the political will of the overwhelming majority of states, whether the international legal order well survives this difficult moment in time, whether it will overcome this crisis without serious damage or change, or whether it will suffer. And each crisis, in my view, also offers possibilities in order to grow out of this crisis even in a better shape. And I mentioned just two elements. The first element is that this moment of crisis should give all those who wish to defend the core of the international legal order to also look with a genuine willingness to be self-critical, so to speak, to areas where international law and international institutions can be improved. There is, for example, at this moment in time, an initiative, a process ongoing at the level of the United Nations to see where this basic organization, the United Nations, can be streamlined, can be made more efficient. And this is a moment to be serious and to make the best of this reform initiative. And the second point, which is particularly dear to my heart, at a moment in time where not only Russia, but also the United States have, at least for the time being, turned away from international law, other states should reach out to form new alliances in defense of the international legal order. And they should step out their traditional regional areas of close cooperation, not to abandon them, but they should go beyond and should strive to form cross-regional alliances, for example, between European states and Latin American states, which are based on the common conviction that this international legal order might be in need of reform, but it should be defended together.
Yeah, okay. Thank you, Professor Kress. I think that this this puts us in a position really interesting to start speaking about this crisis, right? As you mentioned, we're facing a crisis. I don't know if we could or describe it as a legitimacy crisis of the international law, or more like an operative crisis. But at the end, what is important is this call for action, right? We, as many other states, have to start taking action in our hands to change this reality. And because of that point where you pointed out the self-criticism that we should take into account, and from we should start making these changes, we would like also to address a really specific point. And within this context, what place do you think that the crime of aggression occupied today within where is it within today international criminal law?
Now, the crime of aggression has gained, or perhaps one should say regained, a particular importance in the overall edifice of international criminal law, international criminal justice, because of one element of the crisis that I described in my answer to your first question. Mm-hmm. And this is that we have been experiencing, most recently, a frightening disregard of one particular rule of the international legal order, and this is the prohibition of the use of force. And this is not simply one rule of many others. It is not a technical rule. It is not a marginal rule. The prohibition of the use of force is a core pillar of the existing international legal order. The International Court of Justice has called it a cornerstone of the United Nations Charter, and very rightly so, because in a sense, it is the prohibition of the use of force which is the foundation of the entire international legal order. How can you speak of an international legal order granting rights if it was possible to take away these rights by the use of force at your liberty? It is only where a prohibition of the use of force is part of the existing legal order that this legal order is capable of protecting rights. So this is why the prohibition of the use of force is so essential, and this is why it has been such a landmark step that the prohibition of the use of force has been enshrined prominently in the United Nations Charter in Article 2.4. Now, what we have been experiencing recently, and I have mentioned the examples, Russian Federation, I should now be a bit more specific about the United States unlawful use of force in Venezuela. As we speak, we are following with how should I put it, with bewilderment, the unlawful use of force by the United States and Israel against Iran. We have heard open threats by the United States to use force against Greenland, so the sovereign territory of another independent state, Denmark. And we have a number of other territories in the world where the prohibition of the use of force is in a difficult situation. So what does this mean? It does mean if two major powers, Russia and the United States, openly challenge the authority of the prohibition of the use of force, then this prohibition risks for the future to erode. It risks to lose respect. It risks to be seen by other powers. Think of other
China,
powers with territorial ambitions, China, Turkey. You could think of many other unsettled territorial disputes in the world. We are at a moment of risk that this overarching pillar loses its normative authority. And now let's come back to the importance of the crime of aggression. What is the ultimate function of having criminalized aggression under international law? The ultimate function is to provide the international legal order with a sanction to react, and to react powerfully in a symbolic sense, powerfully to a violation of the prohibition of the use of force, and to convey the message that the international community is not ready to accept that breach, but that it wishes to maintain and preserve this prohibition. And therefore, it is not enough to conduct proceedings for war crimes, for crimes against humanity or genocide, all very important criminal provisions in the case of, and I take the example of Russia's aggression against Ukraine. It is important, it is crucial to also conduct proceedings for the crime of aggression, because this crime is the tailor-made reaction to the violation of the prohibition of the use of force. Now, what is the difficulty, and you have asked me about this as well, what is the difficulty that we are currently facing? The difficulty consists of the fact that after the two major foundational precedents on the crime of aggression, which were the Nuremberg trial and the Tokyo trial after the Second World War. At that time, we did not yet speak of the crime of aggression. We spoke of crimes against peace. But basically, the two precedents were about the idea that waging wars of aggression constitute crimes under international law. Now, after those two major precedents, crimes against peace, or the crime of aggression as it has come to be called, have been marginalized in the international legal order for decades. And this remained true even in the 1990s, when international criminal justice experienced its rebirth when the two ad hoc tribunals were established in Yugoslavia and with respect to Rwanda, when the ICC, the International Criminal Court, was established. Those new tribunals, if you so wish, they were concerned with war crimes, crimes against humanity, and genocide, but the crime of aggression remained absent. Or to be more precise, the crime of aggression was under the jurisdiction of the ICC, but it remained undefined, and the ICC could not exercise its jurisdiction over it. Now, An important step was made in 2010 in Kampala at the first review conference on the ICC, when state parties to the ICC ultimately agreed on a definition. And very importantly, not just state parties, also the United States, Russia, and other non-state parties took part in those negotiations. So one can say the international community agreed finally on a definition on the crime of aggression, which you now find in Article 8 bis of the ICC statute. However, because of the fact that major powers among the state parties, France, the United Kingdom, Canada, also Australia, and some others were still very reluctant with respect to the idea that an international criminal court could adjudicate a crime of aggression, the ICC statute includes very severe jurisdictional restraints, which have caused the result that the ICC's ability to institute proceedings for the crime of aggression are much more limited than in case of the other three crimes: war crimes, crimes against humanity, and genocide. And most importantly, the ICC cannot presently take action for the crime of aggression if the alleged act of aggression was committed by a non-state party, such as Russia, such as the United States. And this has led to the fact that the prosecutor of the ICC, Karim Khan, has very soon after 24 February 2022 instituted an investigation into the situation of Ukraine, has also a little later issued arrest warrants, including against the president of the Russian Federation, Vladimir Putin, but only for war crimes and not for the crime of aggression. Now, this situation around the year of 2000, let's say in the summer of 2022 onwards, has been considered by more and more states, by more and more actors in the international community as unsatisfactory. And the most important driving force here was Ukraine itself, not only Ukraine's government, but Ukraine's civilian population, Ukraine's civil society, who have voiced their position very eloquently and very powerfully. And they have put it on the international agenda that it is an unsatisfactory state of affairs, that there is one crime which is very important and which in 1945 was at the core of the development of international criminal justice, which has been sidelined for political reasons ever since. And this, very fortunately, has had two consequences. The first consequence is that a group of states, primarily European states, but including also a number of non-European states, have, after lengthy and difficult negotiations, decided to establish a special tribunal for the crime of aggression against Ukraine. So a kind of ad hoc tribunal, a little bit similar to the ad hoc tribunals from the 1990s in Yugoslavia, or with respect to Yugoslavia and Rwanda. And those states, especially the European members of this group, will come together, and I mention this as we speak, they will come together probably this week and their foreign ministers will meet and will make a political decision on the last outstanding legal text and will politically commit themselves to establish this tribunal. And the significance of this step is very significant. The significance is that it would be possible, if all goes according to plan, to establish or to conduct for the first time since Nuremberg and Tokyo international proceedings for the crime of aggression. So that's the first important development. The second important development is that many states, and in this case not only European states and some non-European states, but that an overwhelming majority of state parties to the ICC have decided to reform the ICC statute. And this is very important for the legitimacy of the international criminal justice system, because it is insufficient to establish a special tribunal that goes after Russian suspects if one is not also prepared to institute proceedings in other cases of aggression. And the only international judicial institution which is capable of doing this mission, to act in cases of allegations of crimes against crimes of aggression in accordance with the principle of equal application of the law, is the first permanent international criminal court in history that we have, the ICC. Now, unfortunately, we have not yet reached a consensus among state parties to align the conditions for the exercise of jurisdiction of the ICC over the crime of aggression with those conditions that apply to the other crimes, but there has been an immense support for this claim, and this has led last year in July 2025 to a consensus resolution of the Assembly of State Parties, a consensus resolution by virtue of which state parties, all of them, have agreed to strengthen the jurisdiction of the court over the crime of aggression. And what is now crucially important, that state parties will follow up on this promise. They have set themselves a target date. The target date will be 2029. So there are 3 more years to go. That seems a long time, but in diplomatic terms, it is not such a long period. So what we need now is a determined diplomatic process, which eventually in 2029 leads to an agreement, or if need be, to a 2/3 majority vote to align the jurisdiction of the ICC over the crime of aggression with the other crimes, to make the ICC statute a fully legitimate instrument also with respect to the crime of aggression.
Okay, thank you. Because I think that with this also brings to the conversation one of the causes of this crisis, right? And it's the operational capacity of the court to face or to bring into justice the persons that might be responsible of crimes like the crime, or better, the person responsible of a crime of aggression. I think that's really important, because that show us how, as you described, this crime or the principles behind them were cornerstones for the enforcement and the creation of these judicial international bodies in the past. But with the time and some particular political interest, they have been I don't know if this is right, but misused or underused as they were supposed to. This brings us to a very important point, and it is the role of the ICC in the international law order, right? In your work, you have described the ACC as a supranational island in an ocean of states, right? We would like to dig about it, or to really know what does that image reveal about the court's actual capacity in the current landscape. So could you explain us to us?
Absolutely. This metaphor, this picture, supranational island in an ocean of states, or the ambition behind this metaphor is to demonstrate a basic tension, which is inbuilt in this fascinating institution, the International Criminal Court. And what do I mean by this tension? On the one hand, the ICC, the International Criminal Court, is one of the most ambitious institutions that exist as part of the current international legal order. Why? Because it is a judicial institution with the mandate to protect genuine global interests, cosmopolitan interests, global community interests. But not only this, the International Criminal Court is designed to protect those values in a vertical manner through an institution that transcends sovereign state, through an institution before which human beings encounter themselves not so much as nationals, but as citizens of the world, and where judges do not act as representatives of their states, but as organs, and I would say direct organs of the international community, to which the protection of values, fundamental values of this community is entrusted. So if you allow me to use a bold expression, if you look at the ICC, you get a glimpse, and I emphasize a glimpse of a world state. Yeah? The vertical realization of the protection of global values. This is hugely ambitious. This degree of verticalism in the international legal order. That's on the one side. At the same time, the enforcement apparatus of this bold institution, composed of international judges, of an international prosecutor, of crimes defined directly by international law, the enforcement mechanism is not genuinely vertical. Yes, it is true that state parties to the ICC are bound under the ICC statute to cooperate with this institution, to help this institution to do its job. But it is still states on which the ICC has to rely to fulfill its mandate. Very practically, the ICC has a detention facility for those persons sought by an arrest warrant and brought before the court. But the ICC does not have a prison where international sentences are to be enforced. So in order to enforce sentences, the ICC relies on the cooperation of states. But even more importantly, the ICC can only conduct trials in the presence of accused persons. The ICC is not entitled to conduct trials in absentia, which means the ICC needs, in order to complete its proceedings, to bring the adjudication of international crimes, its mission to protect global values to fruition, it needs the assistance of states. By surrendering the accused person concerned, and also by helping the court to collect evidence, to facilitate the testimony of witnesses, to provide the ICC with documents. And here you see that the ICC, vertical as it is in its ambition, in its mandate, is still situated basically in an international legal order which continues to follow its traditional configuration. And the traditional configuration is essentially decentral, with sovereign states being the essential pillars. Despite all important new institutions that have seen the light of the day in the many decades after the entry into force of the United Nations, sovereign states remain the key pillars of the international legal order as it exists. And the ICC has not, so to speak, broke out of this system, but it is situated in this system. And now the tension consists in two things. First of all, the ICC will often be confronted with a political reluctance of national states to comply with their duties under the ICC statute. Why? Because the ICC will not invariably act in accordance with the political interest of those states, at least in accordance with the short-term political interest. The ICC might need the assistance of a political ally, of a political leader, which the ICC seeks by virtue of an arrest warrant. And so this allied state, where the accused person has sought refuge, will be reluctant to help the ICC, even despite existing duties. And second, and perhaps even more importantly, the International Criminal Court, the ICC, while clearly entrusted with the mandate to protect global values, so values enshrined in the universal legal order, and not only a regional part of it, the ICC is, as we speak today, still not a treaty system that has been ratified by all members of the international community. The ICC does still not enjoy universal adherence in terms of ratifications and accessions. That means the ICC will quite often, and that's the case today, exercise jurisdiction over nationals of non-state parties. And those nationals very often will still continue to be present on the territory of non-state parties. Take the example that I have mentioned before. President Putin is currently sought by an arrest warrant of the ICC, which is possible because the ICC can exercise its jurisdiction over allegations of war crimes against President Putin to the extent that those war crimes refer to Ukraine, which is under the jurisdiction of the ICC, has accepted the jurisdiction of the ICC. But President Putin, of course, is still on Russian territory. And this means that the ICC is, for the near future, for the foreseeable future, prevented to enforce its arrest warrant. It will not be in a position to carry its mission to the end. And that is encapsulated in the idea supranational island, the highest vertical ambition you could conceive of, and ocean of states with all the limitations, essentially political limitations that this entails with respect to the enforcement of the law.
Okay, thank you for Professor Kress. We would like to make you a last question, because we have spoken about a lot of different things, really interesting ones. We also had, or we now have a lot of questions that will be really important to make you regarding, for example, the situation in Colombia, taking into consideration all the other answers you have given us. But let's stay with the ICC for now, right? And in another opportunity, we think that we will be able to speak about the role of HEP and this particular tribunal in this legal international order. So you have noted a few points that are really important, right? Regarding this legitimacy problem, and how does the ICC operates, for example, when you were talking about the reaction of the Ukrainian population. I believe this is not the only example that one might find about the population of the states parties or populations in the world are think that they have been abused by a foreign government. And like the sentiment is clearly one of the causes of this crisis that we're facing. You said, and it is very important, that at the end of the day, what really matters too in the function of the system is how it is supported by sovereign states, right? So we would like to ask you if you consider that one of the main fragilities of the ICC still lies in its dependence on state cooperation, or do geopolitical pressures and open resistance for certain states, for example, these superpowers, carry greater weight today?
It is certainly true, as it is deplorable, that the ICC has suffered in the past from failures to cooperate as they should from state parties. So I do not wish to belittle the problem of non-cooperation by state parties, which is, if you like, the foundation, the absolute minimum foundation for the ICC to function effectively. We have also experienced from the side of state parties very disturbing signals vis-à-vis certain decisions of the ICC, which do not align with their political interests. And this is true even for states which otherwise, and rightly so, claim to be firm supporters of the ICC. And as I believe that a scholar should always begin to criticize at home, I will mention one German example that I have deeply deplored, and this is the statement of an important German politician who is now the chancellor of our country, Friedrich Merz, a statement that he made before he was elected, that he would invite the Prime Minister of Israel for a state visit to Germany in case of his, Friedrich Merz, election as a chancellor. Now, why do I find this regrettable? The Prime Minister of Israel is currently sought by virtue of an arrest warrant of the ICC with respect to the situation of Palestine. Now, to be very clear, all those decisions by the ICC in the situation of Palestine are difficult ones. Legally, they are controversial, and it is legitimate to have different views. This is not something that I wish to dispute. And I also do not wish to dispute that everybody, including states, may legitimately question the wisdom of certain decisions. It is legitimate that international courts are being criticized. They are not immune from criticism. But one thing should not happen, that a criticism or the expression of a divergent legal view goes hand in hand with challenging the legal authority of a decision made by the court. You can say, I disagree, I have a different legal opinion. I have doubts whether the arrest warrant against Prime Minister Netanyahu is justified as a matter of law. That's possible. But it is not possible for a state party to openly challenge the authority of a legally binding arrest warrant. This undermines the authority of the institution. Now, I'm saying this to make it crystal clear how important it is that all state parties, irrespective of their short-term political preferences, support this legal institution. At the same time, and that was your additional question, we have to acknowledge that the ICC is currently under an even more important and more immediate threat. And these are coercive measures against their personnel. I mention in passing that in Russia, a court has convicted in absentia a number of judges of the ICC for nothing but the fact that they have been carrying out their mandate and have applied the law. And to my mind, even more importantly and shockingly, the current US administration under Donald Trump has imposed a series of sanctions by which the US administration targets the prosecutor, members of the OTP, the Office of the Prosecutor, and a number of individual judges of the ICC. Why? Because they are doing their job under the ICC statute and try to do justice to crimes or to victims of crimes under international law. And the most frightening perspective is that the US, since a while, threatens openly to go even one step further and to impose sanctions not only, that's bad enough, not only upon individual organs of the ICC, but on the institution as a whole. And what does this mean? It means that state parties to the ICC are confronted with a fundamental choice. They could either give in to this threat But giving into this threat would mean that the ICC would lose its independence and hereby would lose what it needs most, the perception of legitimacy. If the ICC succumbs to an open threat from outside and adjusts its work, which should be guided exclusively by the law, to a political and unlawful threat, then the independence of this institution is lost. So giving in to the threat posed by the US sanction is not really an option available unless you wish to, so to speak, give up on this so promising and so important move forward in the international legal order to get serious about the adjudication of crimes under international law. So what is the alternative? The alternative is to protect the ICC and its personnel against those threats. This means protecting the individuals, but it also means to protect the institution and the conditions that must be in place for this institution to work. And those conditions are very basic. The ICC needs enterprises, companies in the insurance area, in the banking area, in the computer science area that cooperate with it in order to allow the ICC to dispose of a working infrastructure. And the greatest threat the ICC and state parties are confronted with is the monetary and the digital power of the United States, by which the United States threaten companies and even non-US companies to follow their threats. So the decision by the Trump administration to threaten the ICC in such an existential manner means that all ICC state parties must be ready to invest even more in this institution, and that very specifically European states, because the ICC is located in Europe and is located in the economic infrastructure of Europe, that they have to achieve as fast as they can digital autonomy from the United States to be able to protect the ICC's survival on their own forces. So what you see here, coming back to your initial question, what you see here is, so to speak, in microscopic perspective, a very important element of international law's crisis and what it entails. There is a threat, a serious threat, but this threat does not mean the end of the legal institution. What it entails is a call to those who wish to defend, to uphold the institution, to step up their energy, to step up their investment in the institution that is at stake.
Okay, thank you very much for your answer, Professor Kress. Yeah, I believe that sometimes we tend to forget that the ICC has has existed for 20 years, yeah, and the superpowers are here for a longer period of time, right? And we have to adjust in the face of needs or crisis. It is the opportunity, as you said, to make things better, to take some action, and to really restructure these kind of institutions for their purpose and to really achieve that. So I thank you very much once again for being with us. I believe, and as you know, that there are a lot of different topics of which we wanted to talk and discuss today. But because of the time, I think that we can. Here, I think that there is a lot of information. We have spoken about different topics that are really, really important for the academic discussion. And yeah, we hope to have you once again in our YouTube channel for another time. So thank you very much. And yeah, we're hoping to have you back again.
I thank you very much first for inviting me, for having this important conversation, and absolutely, let's meet again. And when we meet again, let's focus perhaps on issues such as the complementarity system, the interrelation between the ICC's complementarity system and the fascinating transitional justice system established in Colombia. Let's speak about the present state of affairs in your country and to what extent those two levels, the international level and the Colombian level, can benefit from one another.
Will do. Thank you very much.